Well, since it is right at 11, we will go ahead and get started. Just as a recap, I am going to record this, and everybody that signed up will get a recording. But if you have a family member or friend you think this would benefit for, please feel free to share with them. I want this to be educational for everyone, so feel free to share. But we will go ahead and get started now. If anybody has any questions during the program, if you want to send it to me in chat, or if you want to wait till the end, you can unmute yourself and ask a question, whatever works best for you. But we will go ahead and get started. And then if you could mute yourself unless you have a question, just so it's easier on the recording. We today are going to talk about supplemental needs trust basics. So I want this to be educational for everybody to understand what a supplemental needs trust is, when it is used, and how it is used, and a little bit about the Secured Act, since that's a new act. So we'll get into it. So a little bit about me for some people that haven't ever attended my webinar or don't know me. I am a graduate of the University of South Carolina. I'm a graduate of the University of South Carolina School of Law, and my main practice areas are estate planning, special needs planning, which is in the estate planning, Medicaid planning, and business planning. So our outline for today, we're going to go over what is a supplemental needs trust, first party versus third party, what are allowable expenses with a supplemental needs trust, and how the Secure Act impacts the supplemental needs trust. So the first thing is, what is a supplemental needs trust? It's also called a special needs trust. So they're kind of used interchangeably, but it's an SNT. And it is a trust created for the benefit of a disabled person that are designed not to provide basic support, but instead pay for comfort and luxuries that could not be paid for through public assistance funds. So this is to pay for things above and beyond what SSI and Medicaid will cover for these individuals. So SSI and Medicaid tend to cover things like SSI in particular, your housing is not to pay for your food and not to pay for your utilities and those things. So it is known as supplemental needs trust for that reason, because it is to supplement your basic requirements. A supplemental needs trust still has your basic trust requirements for setting up a trust. We still have a grantor, the person making the trust, a trustee, the person administering the trust, and the beneficiary of the trust, the person who's getting the benefit of the trust. And it still needs to be executed properly, signed, witnessed. I like to notarize them as well, so we have everything there for requirements. A little bit different with the supplemental needs trust. These may need to be approved by the Medicaid office to make sure that they find them compliant with what a supplemental needs trust is. So where your basic living revocable trust, you create it and you don't have to do anything to make the supplemental needs trust, to make your regular revocable living trust valid. This you do want to get, while it's valid, you will want to get it approved by Medicaid. So the first thing is, who really needs a supplemental needs trust? A supplemental needs trust is for a disabled person defined under 42 U.S.C. 1382 CA3. So here's what it says. If he is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment. So this is for a disabled person who's probably going to receive government benefits like SSI or Medicaid in their life because they're unable to maybe work a full-time job, they have a physical disability or a mental disability. It doesn't discriminate which type. But this trust is created so we can allow that person to remain on their government benefits like Medicaid and SSI, because we don't want a person to lose these benefits because they inherited money or they're gifted money, because it's really important for them to stay on Medicaid and SSI. So what we're going to talk about is there's two types of supplemental needs trust. We have a third-party supplemental needs trust and a first-party supplemental needs trust, and there's some pretty standard differences to both of them. So a third-party supplemental needs trust is set up by a friend or family member for the benefit of the disabled person. So it is not set up by the disabled person themselves. It is set up by somebody else. And this one's not as complex as the first party supplemental needs trust. So one thing we have to make sure of with the third party supplemental needs trust is it is not funded with the funds of the disabled person. So this isn't money they've inherited. This isn't money that they have been gifted. This is someone else's funds is funding the trust. For instance, you can have a third-party supplemental needs trust set up so that when you pass away, your assets will go straight into the trust. It was never given to the person individually. It is your assets passing directly to the trust, not passing to the disabled individual. So the big thing about doing this third-party trust is it does not have the Medicaid payback provision. So that is a big thing. It's why you want, if you have a disabled loved one or family member that you want to protect with estate assets, you want to go ahead and set up this third-party supplemental needs trust so it doesn't have the Medicaid payback provision. So for instance, if you set up a trust with $100,000 and the individual passes away and there's still $20,000 left in the trust, that 20 can be distributed how you would like to maybe other heirs in the family if you set up a third-party supplemental needs trust with your assets. The disabled individual cannot serve as trustee, and the trustee has complete discretion on how to handle the assets of the trust. So what we mean by that is normally in trust, we kind of have this basic health, education, wellness, maintenance, and support standard. That's usually what we're going to use in a trust for minors, in a trust for any individual that you're just wanting to keep the assets protected in a trust. So this means that the beneficiary can ask for things like payment to school, and the trustee would have kind of that obligation most of the time to pay it because that's the standard. But with this third-party supplemental needs trust, that is not the standard. The standard is that the trustee is not going to be able to say, I need this, and the beneficiary can't say, I need this asset, and the trustee has no standard to say, oh, we 100% have to give it to them. The trustee is going to make the discretion if they would like to give that asset to the individual. The reason we have this is because if the individual could request and the trustee be forced to give the asset, that money is going to count against their Medicaid and SSI programs, which might make them ineligible. So that's why we have to have it completely 100% discretionary on the trustee. This is a great tool to use for family members to make gifts to their relative without the relative losing their government benefits, such as SSI or Medicaid. And so one thing to note is if you set this trust up and you are the grantor of it, maybe you're the parents of the disabled person, other individuals can still leave money to this trust. For instance, if grandparents want to leave some money to the individual, they would list the trust instead of listing the individual. And so that way, this is a great tool to use for families or friends who want to protect their disabled family member. So that is kind of the basics of the third-party supplemental needs trust. So next, we're going to talk about the first-party supplemental needs trust. And while a lot of the things are the same, such as the trustee is going to have the discretionary power to make distributions, the biggest thing is this has to have a Medicaid payback provision because it is going to be created with the funds of the disabled person. So and a lot of times this happens through an inheritance where maybe mom didn't have a will and everything's just split 50-50 between the kids. And so this person directly inherits maybe $200,000 from a policy, maybe it's life insurance, maybe it was an annuity, and that goes to the person directly. And so they have too much money in their account where they're not going to qualify for Medicaid. So at that point, we can set up what's called this first party supplemental needs trust. But the downside of this is that Medicaid payback provision, because these are the funds of the individual that is disabled. They are going to get the Medicaid payback provision. And if it doesn't have that, then the trust will not be approved by Medicaid. And with first party supplemental needs trust, you always want to make sure you have the Medicaid trust office's approval on these trusts. They'll review it before it's executed for you. and they will tell you if it's going to be executed, that if it will meet or not meet the standards. So that way we can make changes if we need to. This is created by the disabled individual or their legal guardian or parent. Back a few years ago, President Obama made a order that allowed a disabled individual to actually set up their own supplemental needs trust. So this is a great thing, because a lot of times a disabled individual who's receiving SSI and Medicaid has the mental competence to set up their own trust. But before this was passed a few years ago, if they got an inheritance or they got a personal injury settlement, they would have to go to the probate court and get a conservator appointed to be able to set up this trust for them, which was just an added expense. And you have to have some doctors involved in different things with conservatorship. So it wasn't a great situation for that individual, where they were having to rely on a court process, and it slowed things down. But now this disabled individual can now set up their own supplemental needs trust, which makes things a lot better for the disabled individual. One key thing with this is you need to be under the age of 65. That's just for different Medicaid rules. When we set up a first party supplemental needs trust, you have to be under 65. So this is kind of the situation where the family didn't plan ahead and didn't have that third party supplemental needs trust created. They inherited and they need to put it there so they stay on Medicaid or SSI, or in the situation where the person maybe got a settlement from a car accident or nursing home case, then we have to put in this first party supplemental needs trust. So if a person does inherit or receive money that is on disability, SSI, Medicaid, we can set up this first party supplemental needs trust, but we always are going to have that Medicaid payback provision. So that is definitely a drawback to using the first party supplemental needs trust, but we still can create it, and it's still a benefit to the disabled individual, so they can keep on their SSI and Medicaid, which is really important to those individuals. So here are some just SNT basics that kind of everybody needs to know when they're setting this up. The trust tends to be irrevocable. It's always irrevocable for a first party. Third party, sometimes it's not, but most of the time they're irrevocable. The trustee has a big fiduciary obligation. They have to administer this trust properly. They have to make sure if the trust needs to file taxes, it files taxes. They need to make sure they are following the rules of the beneficiary. They're not giving out assets they shouldn't to the beneficiary. And how this works is just a little side note for a trustee of a supplemental needs trust is, if say an individual that is disabled needs to have a supplemental needs trust created, they have that happen, is set up, and now they need something to be paid from the supplemental needs trust. For example, they need a dishwasher. Well, what happens is the beneficiary tells the trustee, hey, I need a new dishwasher, mine's broke, we can't fix it, and I would like to purchase this dishwasher from Lowe's, for instance. So the trustee in their discretion says, okay, a dishwasher is fine to purchase, it's something they actually need, but they're not going to hand this $400 check over to the disabled individual. They are going to make the check to Lowe's. They're not going to make it to the beneficiary. It's going to be to Lowe's, or they can go online and pay for it. You know, in today's time, there's a lot of tools that help with setting up accounts and everything. But the big thing is this individual that's disabled never receives the cash in hand. It's just going to pay for their assets. And that's the big thing with being a trustee of a supplemental needs trust, is there is a lot more regulation for you to follow. So the trustee needs to keep records of all expenses. I recommend, either if you're good at using Excel, setting up an Excel spreadsheet to keep track of everything, or you may even, some of my clients have considered QuickBooks as their trust, if they're a trustee, to make sure they're properly doing everything. And a few of my clients have actually used their accountants to help them make sure they're doing everything properly and treating it that way. So there's different things a trustee can do. And if you are a trustee of a supplemental needs trust, I think it's important that you have your team of professionals to help you, such as an accountant, financial advisor, and an attorney, to make sure you're doing everything properly. Sometimes a trust is going to have to file a tax return like we talked about, so that's where you want your accountant involved. You may need to get an EIN number for the trust, depending on the situation. And one thing is, if you are a family member of a disabled individual and you are unable or don't think you can handle doing the trust, that is too much of a burden on you, that's when we can consider using a corporate trustee if needed. So a corporate trustee would be a company that handles this. The downside is you're going to pay fees. The upside is they usually know what they're doing, they're experienced in the area, and they can help you. A lot of times your bank will have a corporate trustee that you can use, and there's private trust companies that have corporate trustees. So here in Spartanburg, we have various options, and I always recommend talking to them, seeing what the fees are, and picking the company that works best for you. But that is definitely an option, and it's one to consider if nobody thinks they can handle being the trustee of this supplemental needs trust. So the big thing with the supplemental needs trust is you don't want to pay for anything for the disabled individual that you're not allowed to. So there's allowable expenses and things that aren't allowed. So what not to purchase is anything that should be covered by SSI or Medicaid, such as food, housing, utilities. This could reduce their income amount. For instance, if the trust pays their rent that month and they're getting $700 SSI and their rent's $300, SSI could reduce by $300 down to $400. So this trust, like we talked about, is really used to supplement the individual. It can pay for things like electronics. It can pay for education if they want to take classes, go to college, or if they want to just learn a new trade or skill or anything. It can pay for stuff like dental care. Medicaid does not cover dental care, so that's one area that a supplemental needs trust may need to pay for a person's medical expenses. It can pay for a vacation, and you can even pay for a companion to go with the individual to have somebody to help them with their trip. It can pay for household needs like appliances and personal products like soap and those type of things. It can pay for gym memberships. The list is very long on what it can pay for, but it is important to always know what you can pay for and what you can't. And what you can't are things that should be covered by SSI or Medicaid. And Medicaid is not going to always cover everything you need. For instance, they won't cover certain types of wheelchairs. So we may want the higher level wheelchair for that person. And it's okay for the trust to pay for that. Usually when my clients are setting up a supplemental needs trust, I give them a letter that has kind of a long list of normal allowable expenses. But if you have questions about that, you can always email me and ask, or call me and we'll talk about it. But being a trustee of these trusts is a responsibility, so it's important to understand those allowable expenses. So changing gears just a tiny bit, we're going to talk about the Secure Act and how that's affecting special needs and supplemental needs trust planning. So the Secure Act, most of us know, passed in December of 2019, making changes to retirement plans beneficiaries. So these are things like IRAs, 401ks, anything that has that required minimum distribution. So the things you didn't pay taxes on, or you're going to have to be taxed when you pull the money out. So the basic overview is only certain people are now allowed to have that lifetime spend down. So used to everyone could have it, and now we've limited it. And so for instance, a spouse has that timeline where they can do it over their lifetime. But for everyone else, is required to take the funds out within the 10 years. So that means you have a bigger taxable event. So using an SNT with the Secure Act. So a disabled person is allowed to have the lifetime spend out of the retirement account. And so we can create language in a supplemental needs trust to allow the disabled individual to receive the funds from that IRA or 401k, so they'll get that lifetime spend out and not lose government benefits. So we create a special SNT for the retirement benefits for the disabled individual who's going to be the beneficiary. The funds can then go into the trust, and the trustee can use them for the benefit of the disabled individual without losing the government's benefit, and it might create a better tax situation for you. This is one of those areas I tend to say, let's work together with a team and make sure your accountant and your financial advisors are all on board with doing this. But so many times people have shied away from possibly using an SNT for their retirement accounts because typically a trust only allows for X amount of years on taxes to spend out those 401k or IRAs, but we can set it up properly so a disabled individual, their lifetime will be used. And this may be a plan that you want to think about for using those 401ks and IRAs. So that is something that we want to think about overall. And I think it's a good time to look at the Secured Act and see if this would be a benefit to you for your disabled loved one. So the takeaway from this is don't shy away from using your retirement benefits. This could possibly lead to a better tax situation and help the disabled individual in the long run. And the thing is, you don't have to give your whole retirement account to your disabled loved one. You can split it. I mean, you can work with your financial advisor or whoever is holding your 401k and say, I want 50% to go to the trust and 50% to go to my other child. We can work around that to make that work for you. So kind of like final thoughts that I wanted to wrap up with this to make sure we get in and out of this webinar pretty quick, but we want to create a third-party supplemental needs trust to provide benefits for your loved one without having the Medicaid payback provision. One thing I like to add is if you're creating an estate plan and you don't have an individual that is disabled or would need this supplemental needs trust, you may want to always think about having a contingent one, whether it's in your will or you have a trust and you have a contingent supplemental needs trust in there. Because a lot of times life happens and we're not prepared for it. I've had a few clients come to me who inherited money, and at the time their parents set up their wills, they weren't disabled, but they've been in an accident or had a traumatic brain injury. And so now they're receiving SSI and Medicaid. So we've had to go through that first party supplemental needs trust. So I always think it's important to maybe think about having a contingent one in your estate plan. So a first party supplemental needs trust can be used if a disabled individual inherits or gets a settlement of their own funds. The big thing is this trustee does have this fiduciary obligation, so we want to make sure the trustee only uses the funds on allowable expenses. And you want to talk to a professional about using your retirement accounts to fund an SNT if that's something you're interested in. One thing I hadn't mentioned is you can create a SNT through your will. It's the same thing as doing a testamentary trust. You would create the supplemental needs trust, and it wouldn't be funded today, but it would be funded at your passing, and it would go through probate, and the assets could be funded into the supplemental SNT at that point. So there is the testamentary supplemental needs trust as well, or the trust can be a freestanding trust. So there's different options with that, and I think it's important to kind of think about your options, talk about your options, and see which one works for you individually. People ask, do you need an attorney? So I recommend, I'm obviously an attorney, but I recommend for supplemental needs trust to have professionals on board with you, because the last thing you want to do is hurt this person you care about and make them lose their government benefits. So I would say if you're considering setting up an SNT, you want to have an attorney, you probably want to talk to an accountant, and you want to have a financial advisor that is going to help you with everything to make your life easier. And it gives you peace of mind knowing you are protected. So here is my contact information if anybody needs it or has questions about a supplemental needs trust or any questions at all. So you have that there. And once again, we will be sending out the recording. I did get a question during here, so I'm going to go back and look at it real quick and make sure I get everything answered. But anybody else, feel free to send me questions. So one person wants to know, what is the definition of disabled person per government guidelines? So what a disabled person is defined as is we use 42 USC 1382 CA3, and the definition is pretty much if he is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment. So that is a little vague. A lot of times, if a person has already qualified for SSI, that means they are disabled, so this would be a trust that's created for them. One thing we also didn't talk about today is using a pooled trust for a supplemental for a disabled individual. If a person inherits a smaller amount of money where it's not financially the best to set up a full trust for this individual and they're under the age of 65, we can look at using a pooled trust. And in South Carolina, we have the Babcock Foundation. So they would handle all the money for you. The be the trustee, so they would handle making the distributions and everything. So that is something to think about if a disabled individual maybe only inherits, $10,000 or $15,000, and it's not worth the expense of setting up a full trust, is to look at the Babcock Foundation, and that would be in place of the first party supplemental needs trust. So I always like to mention that. Different states have different entities, but here most people use the Babcock Foundation. But we still have a few minutes. I was hoping to get this wrapped up by 11:30, so it's 11:25. So if anybody has any questions, feel free to unmute yourself and ask, or send it to me in the chat and I'll try to answer them. Or if you have questions that you'd prefer not to ask in front of the group, you can send it to my email and I'll be happy to try to answer them for you.
Ms. Ward, this is Gary Davis. Hope you're doing well. Just a quick question. What would be, what would you consider an appropriate amount in effect to have a trust started and not go through like the Babcock?
Well, for a third-party supplemental needs trust, I think you can start it with whatever you want, because that's something we create now that may get funded along your lifetime. And, you may want to put life insurance proceeds in it. So I think for a third party where it's not going to really be active for a while, we don't have to pick a set number for that. But I would say if it's a first party supplemental needs trust, then you may want to look to, I would say more closer, at least over 50,000, probably looking more towards the 100,000. So this would be, if somebody inherited their mom's life insurance and it was a $200,000 plan, I definitely think you want to make sure that you do a first party supplemental needs trust for that. But maybe you just got what was in her bank account and that was $10,000. You may want to look at the Babcock Foundation then. Also, if it's a small amount, you may want to look and say, well, maybe I'm not going to get my SSI this month, but I need to do some updates to my house. That would be an allowable expense. Or we really need to get a new van to be able to better transport this individual. So those are things you can kind of think about too with a small inheritance, is maybe paying some allowable expenses to get that money down so the person doesn't lose their SSI in the long run. So I think that's kind of a case by case, but if you're getting 50 to 100, that's when I would really consider starting that first party supplemental needs trust. If you're under that, I would say we would talk about it and see what your goals are and see maybe if we need to spend down some money or if we want to do it with the Babcock Foundation. The Babcock Foundation does have a payback provision that goes to different charities, and it also does have a fee. So that's kind of things to consider there. The next question I got is how this can be used for charitable purposes for the remainder. So if you set up a third-party supplemental needs trust and you want to make sure that you have a charitable person that you want to give it to, maybe you have your alma mater, maybe you have your church or anything or you have a hospital foundation that's done a lot for you, anything that's a 501c3, we can use this money at the end to go to a charity. And one thing I always like to mention when we're talking about any type of trust or any type of IRA or financial account, you may want to think about using your IRA and splitting it. If you're wanting to give to a nonprofit, you may want to think, well, I'll give half to my disabled family member and then give the other half to a charity. Because if you do that, there's some good tax implications for that, because charities aren't going to have to deal with the taxes like your family member would. And I think that's an important thing to consider in your overall plan, is how you want it to be handled. Do you want to give to charity? How do you want to handle your children? How do you want to handle your disabled child? Or in any situation, if you're wanting to give to charity, I think that's an important time that we have a conversation with your financial advisor, with your banker, or with your accountant to make sure we do the best thing for you. And we possibly want to use some of those IRAs and 401ks to fund giving to a charitable organization and your disabled individual. So that way you get the best tax benefits for it. Does anybody have any other questions that you want me to answer? I'm happy to take any emails or anything for it. If you have questions in the future. But I definitely hope this was educational for everybody, and that if you have questions about a special needs trust, you have a little bit more understanding now, because anytime you're going to go talk to a professional about these things, good to kind of have an understanding about it beforehand. So I hope you got some educational tips. As I said at the beginning, I'm going to send out a recording to everybody. So if you want to send this to any friends or family members you think would be beneficial, feel free. Or if anybody has any questions, I'm happy to look at them through email or give me a call, and I'll be happy to talk to you. But I want to thank you all for attending today, and we're going to have some more webinars coming up in the future, some about business, some about estate, some about Medicaid, and I look forward to hearing from any of you with any questions. So thank you all for attending, and since I don't see any more questions, we'll end this meeting, but I'm glad you all attended, and please feel free to call on me with any questions.